Hello, my name is Patrick Wilkins. I'm the editorial director of talklawglobal.com, which is a knowledge portal for general counsel, and we have members from all around the world. We're here today to discuss the latest developments and recommendations in managing work with external law firms, and I'm very happy to be joined by Anthony Kenny of Boston Consulting Group and Rob Thomas, one of the founders of Serengeti, and of course now part of Thomson Reuters. Anthony, could you introduce yourself, please?
Yep. So Patrick, as you said, I'm senior counsel in the Boston Consulting Group legal team. Boston Consulting Group is a management consulting, provides strategic management consulting advice to a whole range of clients across many different sectors. Our team is about 13 lawyers based in Boston, London and Paris.
Well,
my name's Rob Thomas. I was one of the founders of Serengeti, which is one of the most widely used matter management e-billing systems. I started doing that about a dozen years ago. One of the things that I did early on with Serengeti is built a relationship with the Association of Corporate Counsel, where we did an annual survey of their membership. So we collected quite a bit of information from those law departments about the latest things that they were doing to get better control over the work that's being done by their outside counsel. Before that, I practiced law for about 20 years with large law firms, small law firms. Did a stint as a managing partner with a law firm, and then I moved over to the corporate world when I moved to Serengeti.
well, okay, so let's start with you, Rob. I think probably our viewers will be interested to hear what you have to say about the main trends that have emerged over the past decade or so in corporate legal departments.
So I think, Patrick, the key thing that I always think of when I think of trends in the in-house legal profession is the relative prestige of in-house counsel. I think that has grown dramatically over the past dozen or so years, and probably a variety of factors that have influenced that. The quality of people that are in-house is amazing. Many of the top people from law firms and government have moved to in-house positions. They get to play a business role as well as a legal role. They get sometimes stock options and other compensation that aren't available in law firms. And they enjoy being the client. So what we've seen over the last dozen years is a shift, I think, in the relative prestige of in-house positions. During that same period, we've also seen some change that I think has been driven by economics. We've seen a couple of recessions. Back in 2000, there was the internet bubble that burst, and then there was the longer recession, which started in 2007, 2008, which we're still coming out of. And I think those recessions have put pressure on the corporate clients to get better control over their spending, which in turn translates into managing more carefully the work that's been done by their outside counsel. So the law departments are under generally increasing pressure to not only practice legal work, but to manage legal work in a way that's fiscally responsible for their companies. And as part of that, we've seen the in-house lawyers, because of this fiscal pressure and this expectation that they run their law departments more like business units, more pressure to put in place certain controls, and part of that certainly is technology, which we can talk about later on, looking at ways that, like the other parts of their company, they can use technology to become more efficient, to become better managers.
Just before we get on to that, though, why don't we just talk a little bit more about the pressure that there's been on fees, because our own research suggests that some legal departments, particularly global ones, have had to cut by as much as 40% what they're spending on law firms. Does that concur with what was happening in the States?
40% is higher, I think, than what most companies are finding, but at a minimum, what we're seeing is that most law departments are expected to handle an increasing volume of work. I mean, the regulatory work increases every year, the businesses are growing, and they're expected to handle that work without any increase in either their internal staff or the money that they're spending on outside counsel. And some, as you say, have had to actually look for ways to decrease their spending, even if the work is increasing. So certainly all of these factors are ones that we're used to seeing. And as a result, we've seen that there's been a significant decline in the annual increase of hourly rates that law firms are able to charge that has seemed to match those years in which economics have been a problem. So back in the early part of the decade, 2000-2001 time frame, the annual increase in hourly rates was about 10%. And then when the recession hit, that started to drop down to more in the 5-6% range. It stayed relatively level until the recession hit in 2007-2008, declined again. It's kind of this ratchet effect. We haven't seen it come back up, but it went down to maybe 1-2% from a high of 10% 10 years earlier, and has been staying in that lower range. Now we're starting to see some indications that the law firms are picking things up a little bit, but it'll be interesting to see, God willing, if the economy picks up, whether the law firms then start to try to raise their rates at a higher rate than they have been in the past, because in-house counsel, I think, have effectively used these times of economic hardship to put more pressure on the firms to decrease that annual increase that had become kind of a carte blanche at one point.
Yeah.
Is this what you're finding, Andy?
Yeah, I just wanted to pick up on a few things that Rob has said, which I think are all really relevant and important. Definitely, I think there's a real shift in the prestige of general counsel. I think that's linked and driven also by a new generation of general counsel being prepared to become more businessman-like. And I think technology is really enabling that. Technology is enabling us to get access to information ourselves, and that impacts the relationship we have with law firms. I think the recession has definitely driven a need to focus on cost, but more or less from a cost reduction, more from a value. What is the value add to the legal services that are being provided? And which involves us having to focus more on the metrics and understanding what legal services we're buying. And all of the technology and all of this awareness of how much things are costing is forcing lawyers to really think much more about project management, and these tools help us think like that.
Mm-hmm. Yeah, I mean, I wonder if if we're now in a period where this is the norm for as long as we can see into the future.
Well, I think certainly we're at certainly in the UK. I don't know what it's like, Rob, in the US, but I think the introduction of alternative business models, in-house teams effectively selling legal services to other legal teams, the onset of legal process outsourcing, all of these are, I think, really challenging the historic way that law firms have interacted with law departments in a way that I think is...
indeed with the other departments in the business.
Yeah.
I remember a conversation we had where you described them as a fiefdom, didn't you? It's quite interesting. Yeah.
The law department used
the
to be
law
a
department,
fiefdom.
yeah.
But as Anthony is describing, I think the law departments now are having to interact with procurement, with accounts receivable, with other parts, of course, their business clients at the company. They're just becoming part of the team, and the expectations on the lawyers are similar to the expectations on any team member. You're expected to be accountable for what you're doing and for what you're spending and for the results that you achieve. Whereas before, I think the law departments were getting away with kind of being their own little world and nobody watching very carefully what they're doing. That certainly has changed.
You think that was true, Anthony?
Yeah, I think there's much more expectation of lawyers through dashboards, through reporting, through analysing data to be able to articulate the value they bring to the business in a way that the sales department and or the procurement department have had to do for many, many years. And I think, as you say, historically there was maybe this mystery as to what the legal department, what the lawyers do. And I think more CFOs and more CEOs are sort of expecting more transparency about what we do and where the money is spent.
You could, of course, state a case, though, couldn't you, for the legal department keeping an insular aspect to it, because it is supposed to be independent and able to be objective on everything, isn't it?
Well, it is, but at the end of the day, they have to achieve the purposes that the business has to make money for the shareholders. And they have to operate the legal team like any other business unit.
But could this not be to the detriment of the protection of the company?
Well, I think you can run your unit like a business unit without necessarily changing your values or the way that you operate or doing something that might jeopardize the attorney-client privilege. You're just doing it within a different context, and that's the context that Anthony mentioned of metrics and so on.
Yeah, I think there's a separation of the role of the lawyer as business partner, and as business partner being able to have conversations and articulate your service in the same way as other business folk do, but then also remembering your professional duty and to the ethical conscious of the of the firm and of the business. You can separate those two roles and they can work side by side, I think. Yeah.
But of course, there has been a movement away, hasn't there, from the in-house lawyer sitting on the board of the company because of these very independence issues, and that's why I'm persisting really in there needs to be a degree of independence, doesn't there, so that they can haul in the CEO if necessary.
Well, and in some cases, the in-house lawyer wears multiple hats, right? They're in some contexts, they're offering business advice as well as legal advice. So it has, I think, become a more complex role as these different functions begin to intermingle with each other. But I think most in-house counsel become very effective at becoming lawyers, keepers of the ethics of the company, compliance officers, as well as business people.
Okay. So I guess we should move on to technology is beginning to creep in, isn't it? But I don't think a lot of people who might be watching us today actually understand where the technology fits in. So can you kick us off on that?
Sure. I think to take a step back, I think what we need to look at is what are the things that most law departments are trying to accomplish in managing legal work, and particularly managing legal work that they decide to give to outside counsel. The first decision is, do I keep it in-house or do I give it to outside counsel? But with both types of projects, I think lawyers are learning to be more systematic in the way they manage that project. As we talked about earlier, with a kitchen remodel, you tend to have a plan, a budget, you monitor how you're doing against that plan, and at the end you take a look back and see how you did. And with legal projects, I think these concepts are just starting to become applied in a more systematic way. So what we are seeing is that before there's any talk of technology, there is a desire of the law department to get more control over what's happening on its legal projects and to get more accountability for the way those projects are taking place. So we're seeing, I'd be interested to hear what you're seeing, Anthony, on these. We're seeing wider use of retention agreements with outside counsel. Instead of just signing the letters that the law firms give them dealing with conflicts and paying of bills and so on, what we're seeing is law departments saying, this is the way that we as a company want to work with all of our law firms. We want to have a standard set of rules of engagement that govern things like how often are we going to be billed. We don't want to get the bill 6 months after the work was done. How often will rates be changed? We would like to have advance notice if you're going to change the team on a major project. We don't want to see people cycling on and off of the projects we're managing. These are just examples of the kinds of rules that we're seeing in the...
And all managed by technology, of course.
They can be, but
yeah.
Again, the first step I think here is to decide what do we as a law department, as a business part of the company, want to accomplish with the law firms and the people that we're working with internally. Then you can decide what tools are best to accomplish those things. So first you need a consistent set of agreements, and we're seeing about half the law departments in the United States now are engaging in some sort of uniform agreement across their panel of firms that they work with regularly. Then, in at least major projects, getting a plan and budget. Sitting down with the firm who's going to be handling that project and having a meeting of the minds as to a level of activity, as to who the players are going to be. Do we want this to be heavily staffed by partners? It's a high-level set of work where the partners can be most efficient. Or is there going to be a lot of low-level work? We want to see more associates and paralegals or legal process outsourcing. What is the budget to be for this? Is it a matter that we expect to spend £100,000 on? Is it something we expect half of that or 10 times that. Sometimes if you don't have this conversation, the law firm's going in thinking, well, this is something that we're going to spend this on, and the client's thinking a tenth of that, and when the client gets the first bill, they quickly realize that there hasn't been this agreement as to a level of expected activity. So at least having that conversation, and in some cases putting together a formal budget, which could be as simple as a single figure for the project, or it could be down to the month, or it could be split out by activities, whatever makes the most sense in a project, but having some sort of meeting of the minds at the beginning of the project as to how that project is to progress. And then having a way to monitor progress against the plan, whether you have a monthly status update or some sort of budget to billing comparison on a periodic basis. How are you going to see if those projects that you really want to make sure turn out well are going according to plan? Do you need to adjust the plan? Has something changed in the initial assumptions which is going to cause you to change that plan? And then at the end, looking at the results that you got, saying, is this what we expected? Did the law firm do a good job here? Are there some lessons that we learned from this project that we can take to other projects, either ones that we handle with this firm or with similar projects with other firms? So I think I'd be interested to hear if this is what you're seeing, but what we're seeing before the technology comes a recognition that there needs to be more systematic management of legal projects.
So it was a sort of discipline, really, Anthony, I suppose, wasn't it, in the earlier days? I mean,
well, what I find fascinating about listening to Rob is, you know, he's using words like manage, project, plan, and whereas lawyers tend to probably think in cases and matters. So
Files.
In files, and I think, but what's good about technology is and the progress that is being made is that as a community we are moving more and more towards appropriately using that type of technology, terminology, because you know, there was some interesting thinking from the likes of Richard Susskind and you know, about certain aspects of the law becoming commoditized, and I think that's true. And I think we have to, as a legal community, whether it be combination of the in-house community and the external lawyers, recognizing that there are things that can be commoditized, and those things that can be, let's get them done at the lowest, cheapest cost, and let's use the technology to help us understand how services break down, how things can be project managed, how things can be planned. And I think the technology enables those kind of conversations because it gets us into the mindset and it gives us the terminology to use to have those sensible conversations.
so when we're talking about technology, and I know that later on we're going to talk about e-billing, but are you talking about Outlook or matter management, or I mean, what are you talking about in terms of early technology?
When you look at a typical department, there are a whole range of potential technologies that you can use, and depending on where it will depend on the size of the department, what work the department has, and also where they are on this evolutionary path of being, I suppose, traditional lawyers through to more project management lawyers, if we can call them that. You know, so Outlook is the basic, and I think everyone's on Outlook, and I think it's a great tool. But also you've got SharePoint, you've got e-billing, you've got matter management, case management, you've got tools that help you with compliance, contract management, project management, you know, entity management, lots of different tools out there. And you know, some departments are just using certain tools, some are using approaches where you can link those things together in a kind of more holistic fashion. So I think it varies, and I think the interesting thing is that we're all now starting to talk more and more about technology.
But of course it started in the US, without a doubt, didn't it, Rob?
Well, I think probably the ideas are common everywhere, but it seems that a lot of these technologies you've described are moving ahead fairly rapidly in the US. And it's funny, when I try to get a sense of whether a law department is using technology fairly commonly, what I usually start with is I say, I'd like to talk to your person who's producing reports about what the law department is doing. And often what I find is that person is just one step above the stone tablets. I mean, they've got a piece of paper, or maybe
Excel.
they have a spreadsheet, maybe they've got Excel, and they're typing things in, or they've got a Word document that's got tables on it. These are just things that mimic the paper world. So the next step up then is to do the kinds of things that Anthony described, having some sort of technology system which makes it more efficient to collect the information, to organize it, to run reports out of it. But I think most law departments are just starting to think about how can we more effectively put systems in place to manage the things that we want to do.
And yet we know that they are still obstinate, aren't they, about turning to technology and everything. You must know this from talking to the legal departments that you talk to. There is a certain obstinacy there, isn't there?
There is. I think those of us who went to law school didn't go to law school because we were risk takers. We like systems and planning, and we're very suspicious of the newest, latest, greatest thing. We spend our days with people who have had bad outcomes because they took chances and didn't turn out for them. So I think as lawyers, just in general, of course there are exceptions to every rule, but lawyers in general tend to be a conservative bunch. Mm-hmm. And we like to stand back and see what works before we jump in and do it ourselves. But
so you forgive them then?
Well, I'm one of them, right?
Yeah.
I don't use a computer because I love it. I use it because I need it, and because I feel like I would be behind if I weren't doing those things. And as I've gone to work with Serengeti and help develop systems for lawyers, I'm sensitive to the fact that lawyers don't have a lot of time to be trained. They don't have a lot of time. They're not using technology because they are eager and they love to do it. They're doing it because it makes them better at their jobs, and it has to be fast and easy to use. And the systems that Anthony mentioned are ones that are just starting to take hold, and those companies that are doing it generally have found a lot of success, but there is a definite amount of resistance that has to be overcome.
And is it true that in BCG you are and you aren't using technology? Is that what you're saying, basically?
Yeah, we use, I suppose we're at the first stages of using technology, so we use Outlook and we're using SharePoint to try and get into the habit of central filing, because at the moment we are, like many departments, using our laptops and sharing information that way. But to Rob's point, there's a real learning curve here. I think you don't go to law school to do administrative work, right? You want to solve the client's problems.
That's my point, actually.
Yeah, but inevitably, as the technologies improve, this is less and less and less. But inevitably, there'll be some administrative work involved in any kind of tool, and it's for lawyers getting their head around the initial input is worth the value they get at the end. So there's that return on investment of time in terms of the training they have to attend, in terms of putting the information into the system. So it's a real change management exercise to get a legal department to move from historic ways of doing things into the technology.
So we have a little way to go.
As Rob said, there are some departments that are really flying and succeeding using this technology. But I think when you look at the legal community as a whole, there's still some way to go, I think, before we're all comfortable with using the technology.
Now, one of the things I've been picking up on my travels for the past 2 or 3 years is there seems to have been a huge surge in e-billing. A huge surge, I say, but there's still a lot of companies that don't have it. And for the benefit of anybody watching us, Rob, what does it mean, e-billing?
So I was thinking of this when Anthony was describing one of the key things that people are concerned about is entering all this information into whatever new system you get. One of the neat things about e-billing that I think most people don't realize is that e-billing pulls the information from the law firm's time and billing systems into a system that the client has, so that it eliminates that entry of information, at least from the bills. That information comes out of the bills. So most people, I think, when they think of e-billing, they think that it's a picture of the paper that they're currently used to seeing in a legal bill, but it's in electronic form on their screen, and that is totally wrong. I mean, that's not even close to what legal e-billing is. So legal e-billing, the law firm does everything that they normally do, but instead of printing out a piece of paper and mailing it to the client, they put all that data, all that information into an electronic file, and they can put hundreds or thousands of bills into one file. They send it off to a vendor like Serengeti, And the beauty of that is that the client has all of this information. It unlocks that information that has been trapped in these legal bills for years, so that software and systems can analyze that information so that the client can see things that they want to see. So for example, when a legal e-bill comes in, the software can analyze that bill and tell you, is there a person on that project who's never been on that project before? So if I have a guideline with my firm saying no new people without my pre-approval, I can see with that bill 3 new people. Sometimes we call them drive-by timekeepers. You know, they come and they spend a couple hours and then they disappear. I can see immediately if there's someone on that project who's never been on it before. I can see if anyone's changed their rate. So if I have a guideline with the firm saying you can't change your rate more than once a year, whatever my rule is, I can see that that has happened. And in fact, just a quick example here, recently we had a general counsel who said, saved $60,000 with one phone call in my second week on Serengeti. So how did that happen? He said, I got one of these bills with an indication that one of our outside counsel had raised his hourly rate by $60. Now in the paper world, you can imagine how difficult it would be for me to discover this. I'd have to go look at the bill from the previous month, compare all the hourly rates, and catch this. Never would have happened, because lawyers don't spend their time doing those things. But the system told me this, so I just picked up the phone and I said, why is this person raising their rate in the middle of the year? And they said, oh, he raised his rate for most of his clients, but that was a mistake. We didn't mean for that to go to you. Whether it was a mistake or not, who knows? But they said, we will lower that immediately. And he said, I went and looked, this guy spends 1,000 hours a year for us in a normal year. 60 times 1,000. He says, I would have totally missed this, $60,000. So the beauty of getting all this information and having software analyze it is that you now know things about that bill that you wouldn't know otherwise. It can also summarize, tell you how much partner time, how much associate time, how much paralegal time in that bill. So you can at a glance see if the staffing is what you expected.
And will it go into a specific task that's been performed as well?
You can look at that bill rearranged any way you want it. So we have an electronic bill now. It's not just an image, it's data. So I can say, I want to see the bill ordered by tasks. And if the only way you can do this is if you require your firm to put task and activity codes with each line level. Most clients aren't doing that because it involves a lot of extra effort.
Just explain how the codes and the tasks work.
So as outside counsel, I had to do it. Most of the time in billing systems have the ability with a drop-down menu, when you put in whatever your activity was, it tracks your time, and then you pick a task code and an activity code out of the drop-down menu. And then when the client gets the bill, they can see broken down by task and activity each item, and you can organize the bill so you can see how much time was spent on motions or whatever category you want to see. But again, this requires the law firms to code their time, and you can imagine some firms are better at doing it more accurate than others.
So you're not using that system at the moment, Anthony. So how do you handle all of that Rob's been describing?
Well, it's listening to Rob. It reminds me of yes, the pain that can go with the manual processes of well, there's several things come to mind. When you're dealing with international law firms, they're not all necessarily sending you information, even from the same law firm, in the same way. So that's, I'm imagining Rob Serengeti would help with that, in that a law firm will communicate with you in a consistent way if you're dealing with one panel firm. Because you can, you know, different countries will have different ways of recording their time and how they present the information to you. And so having to adapt to that. But then also getting behind the data when it's a manual build inevitably involves phone calls and emails and chasing in a way that you could do yourself with an e-billing system, I guess. But then the one that really resonated with me is, then if you've got a relationship and you get a bill in, say, October, to check the rates, you really have to keep going back to the engagement letter, which may be the beginning of the year, or maybe from 2 years ago. You agreed a certain number of rates in your engagement letter, and is that being maintained? And if there's an uplift, is that because of an annual uplift, or is it because someone's been promoted, or I mean, what are the reasons for that?
Well, and it's interesting on that specific point. We had a customer using Serengeti, American Express, who found that the law firms were telling them that they were giving them, say, a 5% increase. but what they found when they ran the new billing rates through the bills of the past year is that because the people they were using had more than average increase at the firms, they were seeing a 10 or 15% increase. So assuming the work was going to be the same this year as it was last year, if you use those new rates, it was a much bigger increase than what they were expecting. So if you budgeted for a 5% increase, you would have had a real problem at the end of the year. And we actually do that in the system now. We take the new rates, run them through the bills of the prior year, so you can see exactly what a rate increase will mean to you, assuming the work is similar to the prior year. So I guess the beauty of having all this information now is that you can see things in different ways and run reports that just would be impractical for anybody to do in the paper world, because you'd be so much data entry it wouldn't be worth it.
Sorry.
Yeah, I was going to say, I mean, presumably Rob, also it helps an internal department with their predictive budgeting as well, in the sense that if you've got litigation or transactions coming up, or or suspect they're going to come up, you can go back into the system and say, okay, of course cases are different, of course transactions are different, but in the past 2 or 3 years, these kind of transactions, these kind of cases cost X amount, these steps cost X amount, and you can run reports and identify trends and all sorts of things.
You can even use it to set alternative fee billing arrangements. So you can say, in the past, we've seen that on average, this type of transaction has cost us this much. How about if you, our outside counsel, agree to take this on a fixed fee basis? We'll pay you, say, 80% of what the average was. If you bring it in under that, then we'll split the savings with you. But you can't have those kinds of discussions unless you know what things should cost. And the only way you can know what things should cost is to look back through history and compare apples with apples to make sure that you have an idea of what something should cost. Then you can start to say, if you can beat that average, I'm willing to share the savings with you. That way the law firm can actually get more than its hourly rate if they do a better job, which is the opposite of the way hourly rates typically work. Their incentive is to bill as many hours as possible. But you can set up fee arrangements that would incent them to actually keep the hours down, because they would get more than their hourly rate.
What has been the reaction of the law firms? I can imagine they probably overall earn less money. Now we're in the recession and everything. So what's been the reaction? Hostile, or let's work together? Or?
That's changed over the years. But a dozen years ago, when we first started doing e-billing and online matter management, we're getting not only bills, but documents and status updates and other information from the firms. But I think there was a lot of suspicion at the beginning about where this was all leading. But I think most law firms now accept the fact that corporate clients want more information. And I think most law firms feel at the end of the day it's a good thing, because if they're doing a good job, let's say that I am able to handle a transaction for my clients at a lower cost than other law firms, I want that client to run that report to show how much it cost for them to handle it through me rather than through these other firms. So at the end of the day, those firms that are doing the best job, getting good results and keeping costs low, will stand out as top performers, and they will get more work than the firms maybe that aren't. But over time, I think the law firms have accepted the fact that this is just part of the new normal, if you will.
Their own operations were a little bit sloppy, in other words.
Well, I mean, they just weren't in the business of providing this kind of detailed information to clients. And one actual side benefit, as managing partner of the law firm, the biggest headache I had was collections. Getting that money in the door. Accounts receivable was always one of our biggest priorities, because we were financing those accounts receivable by borrowing. And one of the byproducts generally of getting these bills immediately into the hands of the clients, giving the clients the tools to review them quickly and thoroughly and get the payments made, is that the law firms are getting paid faster. In fact, we're even seeing some firms who are giving early pay discounts, 1 or 2% off the bill if they get paid in 2 or 3 weeks rather than 2 or 3 months. It's worth it to them not have to borrow money and pay interest. And they generally, bills, legal bills are not like fine wines. The longer they stay out there, generally I found at the law firm, the less chance they were getting paid. So I would like to get that money in the door as quickly as possible.
So even though you don't have the technology, Anthony, you've seen a change of attitude by the law firms on that, because we only go back 20 years, and some law firms who we don't have to name, it would be services rendered, wouldn't it? £100,000.
Good luck with that these days.
That's right.
Yeah, I've certainly seen law firms get better, whether they use e-billing or the standard paper billing, at articulating what they're doing. But also, and I'm interested in Rob's view on this, for me, the technology, as I said before, is more about enabling us to have the vocabulary to have conversations around project management, and to understand more what we do as lawyers, whether they be external lawyers, internal lawyers, and how we work increasingly together as a team. What I've seen, and I'm not sure it's a product of e-billing or just a product of thinking through and using the technology, is obviously more law firms themselves thinking, okay, maybe we should take this process and commoditize it, send it out to India, or have it done by a team of paralegals. And I think law firms themselves are starting to think about breaking down the tasks and saying, well, what can be done at fixed price. So I think the technology, or at least talking about the technology, enables that thinking to happen, changing the mindset of both internal and external lawyers.
We are certainly seeing that. I'd say the perfect example of that is use of budgets. Mm-hmm. So having a technology system where you can require a budget, I'd say a quarterly status update, and basic information about a project that the law firm can put directly into your file, makes the law firm start to think, well, maybe I should be more careful in the way I budget, because now the system is going to automatically compare the bills with the budgets, and it's going to tell the client how we're doing as we go along. Mm. So I need to get ahead of this, and I need to be better in the way that I budget. I need, instead of sending the client a huge bill that's going to blow through the budget, I need to figure out how to avoid that from happening. I need to provide explanations to the client with the bill instead of waiting for the client to call me. I need to get ahead of this and anticipate those questions. So I think we definitely are seeing that the law firms, the best ones, are anticipating what the client wants. Mm. And they're jumping in and saying, rather than waiting for you to ask me for a budget, I'm going to tell you this is what I think this should cost, because we've done 100 of these, and the clients love it. One of the things my clients used to really appreciate at the end of a project, I always sit down and do a memo, and I'd say, I'm not charging you for this. Here's a list of what we learned doing this project. Here are things that you can take to future projects. We had a discovery request, and it took us 2 days to find these documents. Here they are. We found them. So if you get another discovery request, you know where they are. And I think with these technologies where you can have the law firms put things directly into your file, whether it's a status update or a document or a memo summarizing what you learned from the project, the good law firms, I think, are getting ahead of what their clients want and are eager to provide this kind of thing, because this is what makes them stand out. Yeah. That's the other thing law firms have a very difficult time with. How do you stand out in today's market as a law firm? It's by providing better service at a lower cost. And
just building off what you said there, Rob, I think that's a really important point to draw out. Technology and working together using technology, and a good law firm will proactively use that to reach out, and these are the lessons to be learned. We spent 100,000 on this particular task, because actually, quite frankly, your lawyers didn't get back to us in time, or because, as you said, your information management systems are so poor that we had to manually code this, and so rather than just send in a bill and then everyone just move on, to be able to analyze that bill in a meaningful way and draw out lessons that can then be implemented to save money in the future, I think is really powerful.
So, Rob, let's imagine then that we're a legal department like Boston Consulting Group. What do we have to do to install this kind of technology? How difficult is it? I can imagine, you've got a problem straight away, trying to get a budget for it.
Well, those are kind of different questions. The first thing is, how do you justify such a system at your company so that you can get it, and then how do you implement that system that you bought? To answer the first question, without getting into too much detail, we find that And we have ROI studies that have been done by independent consultants, but we find that the law departments who implement an e-billing and matter management system, they can save so much more time and money over even the course of the first year than the cost of the system, that it's a very easy business case to make. You make that business case by going to other law departments who have done this, saying, what's your experience been? And even just looking at the most basic level of savings, which is the difference between the bills when they came in and what you paid, and generally the savings are far more than the cost of the system.
But what about the training and...
So, and just to finish that point, I think traditionally these systems were just for large law departments, so they were very expensive, very complicated. What has happened over the last dozen years is there have been systems like Serengeti have come out for the proposition these don't need to be expensive. So we generally find that the cost is in the range of 1% or less of outside legal spending, and most companies are saving 5 to 15% in their first year. So that's just an idea of the magnitude. Mm-hmm. In terms of implementing, most companies we find are surprised to find out how many of their law firms are already doing this with other clients. They go, why didn't they tell me they could do this? And so, you know, it's not uncommon for us to have a new company give us their firms that they want to connect with, and all of them, or 95% of them, are already on the system with somebody else. So as time goes on, it's getting easier and easier. Now, I think the biggest challenge as a company comes onto a system, whether it's Serengeti or any other system, is pulling together the information that you want to start with. It really depends on how organized you are at this point. If you've got things on people's individual desks and so on, you need someone to pull that information together so that you can open up projects in your system so that you then have the appropriate receptacles to start billing to, or send budgets into, or documents into. But it doesn't need to be complicated. I mean, you can set up a matter with, say, 10 basic fields, invite your outside counsel, and in Serengeti, there's no charge to the outside counsel, nothing for them to install or maintain, so there's no excuse why 100% can't come on. And then they are providing, as I described, this financial information with each bill. You get a ton of financial information. They can put status updates right into your file. We even have the ability for you to require things, and if you require something and they haven't provided it, the next time they submit their bill, the system will check and will say, sorry, you didn't provide your quarterly status update before the bill goes on. You need to provide that. So the law firms are keeping much of this information current, and it involves about the same amount of work, whether you're going to write a letter to the client telling them about the status, or send an email, or put it into Serengeti. It's the same amount of work, and the advantage of having the law firms put this directly into the system is that it's then immediately available to the client. So we generally find corporate law departments, it's 1 or 2 months. They don't need to drop everything to get implemented. We handle the connection with the law firms. Training takes about an hour or so with your normal attorney who's going to use the system. And the administrators, we do spend more time with 1 or 2 administrators in the law department who are going to be responsible for producing reports and organizing things. And you create templates, for example, of different types of matters, so when you create a new matter, you don't get a bunch of fields that don't apply to that matter. Once you've taken this initial 1 or 2 months, things tend to hum along pretty smoothly. And as I say, most of your outside counsel, I think if you're a law department of a sizable company, they're probably doing this with other people already.
What if it's a particularly sensitive matter? Could you keep it off the system and do it in the way that Anthony would do, manually?
Sure, absolutely.
No
Now,
problem.
the problem with that is when you look at a report, of course, that will not be included coming out of the system. We do have very serious controls where you control who sees what, and you can either do that by groups. You could say, if Anthony's the head of the, say, intellectual property group at his company, he sees all of the intellectual property work going on, not just the things he's handling. Or you could say you only get to see the things you're personally working on. Or you could lock it down and say the only people that get to see this are the general counsel and 1 other person, and whether it's an intellectual property matter that Anthony would normally see or not, he doesn't get to see it. So you can...
So just for the sake of clarity, how would you achieve that?
You do it in the system when you create the matter. You tell the system that only certain people have access to this, and it's The security is throughout the system. So if there's a matter, say, that I'm not supposed to see, when I run a report, if I would normally see that matter, I can't get access to that matter in my reports either. You only see in your reports those matters that you otherwise would have access to.
And so you can choose whose name you put on in that box?
Absolutely.
Right.
You can even, with outside counsel, designate what we have as coordinating counsel. I may have a law firm who's responsible for hiring other law firms to handle bits and pieces of a project. I want them to see those bills from those firms. I want them to manage those firms for me. In other projects, I may not want the firms. I may hire 2 or 3 firms to handle various aspects of a project, and I do not want them to see each other's stuff. We can set it up that way as well. So you have complete control over who sees what. We say treat it like your legal file. One of the dangers of technology, as you know, is very easy to give access to too many people to something. It's a danger with a paper file. You can leave a paper file in the lobby and have a real problem.
How would you feel about that? I mean, do you feel it's secure?
Oh, certainly from the way Rob's describing it, I think it's you know, it sounds as though you can configure it to the level of security that you want, and the access even within the team that you want. So I mean, yeah, because the 2 elements of concern would be how easy is it for those external to the legal team to access the files and the information. How easy is it to for other law firms to see what other law firms are doing, and then thirdly, there may be certain projects or certain things even within the legal team you want to keep, you know, confined. But it sounds from what Rob's saying that all of those things are addressable.
Absolutely. It could be more secure than a paper file.
Yeah.
An electronic file, you have control over who can get where in the system. With paper, anyone who walks by can look at whatever's on your desk.
That's somebody within the organisation, but somebody external to the organisation. Everybody knows that servers are hackable, don't they?
Well, you know, it's the same problem with email or anything else, right? I mean, every time you send an email out, it goes through multiple servers. But there are certain standards in place for online systems. We have an annual audit that's done by an outside firm, checking to make sure we've complied with those standards. Plus, we hire what we call ethical hackers. These are bad guys who, you know, used to break into systems, who now have come over to the side. They found they could make quite a bit of money hiring out their services. So we actually hire them to test the systems. And part of the review when you buy a system like Serengeti is you have your IT department ensure that it meets the standards of your company. And in many cases, the IT department says this is more secure than anything that we can provide here internally, because it's built into the system. This is a part of the system.
Would you have problems, for instance, Anthony, if let's say it was a piece of litigation and there were details going on that bill about what was being done, that if it came out, it would help the other side?
Potentially, but then to Rob's point, whether you use Serengeti or don't use Serengeti, or whether you're using Outlook or paper files, those risks are there, and I think it's just more about how you personally set up your own case management. So whatever technology you use, whatever process you use, it's secure from outside eyes.
One of the criticisms I've heard, though, Rob, you might want to address this, is that to get into an e-billing system, you only need to put in your email and a fixed password. It's not as high level of security as banking, for instance.
Well, it depends on the system. Each company can set up their own login requirements on Serengeti. So you could, for example, say, we want passwords changed daily and they have to be 25 characters and 14 numbers. I mean, it's just a question of balancing convenience versus security. Obviously, the harder it is for a person to log in, the less convenient it's going to be, but the more secure it is. So we basically let each company decide how they want to create that balance in the system.
Right. You might want to say also that I understand the server has been switched to Europe, isn't it?
Not yet, but we're looking at doing that. We've complied with the safe harbor protections of EU privacy policies, and as we get more business in Europe, we're definitely going to be putting a server over here so that we have something that's closer to where the business is taking place. But as you know, the internet, you know, just as I said, sending an email, those things tend to go to multiple servers. And most legal opinions of the Bar Association say that sending something on the internet, there's a reasonable expectation of privacy. So just because you send an email with some privileged information in it to someone who may be in another country and that email goes to different servers, there's still an expectation that's going to be private. The privilege has not been waived.
Does that satisfy you?
Yeah, certainly.
Yeah. Given that, excuse me, in Europe we have the highest standard of data protection and privacy, and everybody else I think has to comply, don't they? And the courts I think would always comply with the highest standard, wouldn't they?
So yeah, I mean certainly having a server within the European region would help you feel more confident and comfortable that you're complying with the EU regulations, because safe harbour is fine, obviously, but if your primary source of sending the data to a server in Europe, that helps a lot, I think.
The initial issue was, shouldn't our server be behind our firewall at the company? Isn't that the most secure? And maybe if you're only working internally at the company, but when you're working with outside counsel or other vendors, and we have accounting firms and other people sending bills in, you've got to blow holes in that firewall anyway. So if you're talking about a system that's going to be connecting various groups outside the company, it doesn't matter whether that server's in the company or outside. You just need to make sure that you have a secure system.
Sure, but I was at a conference not too long ago where Novartis, I mean big global pharmaceutical company, and their in-house lawyer listed 25 reasons why none of their data would ever go to a distant server. So, I mean, how do you get around that?
Well, as you can imagine, there are a variety of opinions on that, and I'd be interested to hear what his or her specific reasons were. But all I can say is we have companies who know the most about internet security: Amazon, Symantec, McAfee, American Express. Their most sensitive legal data is on our system, and they have, as you can imagine, before they let that happen, they went through it with a fine-tooth comb and made sure that there were no regulatory issues and no security issues. So each company kind of does their own due diligence, but as a vendor, we can help them through that, because we know that if our system is not secure, we don't have a system.
Yeah, quite, yeah. So you will keep on working, in fact, on these issues that have been raised?
Absolutely. It's a constant moving target. You can always do better, and there's new regulations every day.
Okay, well, I'm mindful that we're coming to the end of our discussion, so a nice way to finish off might be, why don't we, Anthony first, any recommendations you would give to your peer group, and then Rob can tell us the same.
Well, as we've been discussing, I think the move to technology is an evolutionary process that's going on, and we should all embrace it. But I think if we're going to embrace technology, we have to understand, what are the drivers for our business, what is the business looking to get from us as a legal department. We then can think about which law firms are we going to work with and how are we going to work with them. And then I think choosing the right technology that will enable that conversation to happen, to have adult conversations about billing, to have adult conversations using appropriate terminology around project management, and moving more towards project management and planning.
Couldn't have said it better. I think the important thing is for in-house counsel to feel comfortable having those conversations. I think many in-house counsel are hesitant about the reaction that they think they might get from their outside counsel, and what they don't realize is that those outside counsel are already having those discussions with other clients, that everyone is looking for ways to be more efficient, to be more effective, to work together more closely, and that the law firms are already using many of the technologies that are being used by other clients. So if I would finish with one thought, it's to encourage in-house counsel to be more active in having those conversations with their outside counsel, because most of the outside counsel want to have that conversation. They want to do a better job for the client.
But just finally, both of you, looking down the telescope 10 years on, where do you think we'll be briefly?
I think we'll be using much more technology. I think we'll be using technology for e-billing, for matter management, for contract management. I think we have to. It will enable us to be providing better value to our businesses.
I think the current trends of being able to see everything and do everything no matter where you are and connect with anybody are going to continue to get greater and greater. It's going to be harder and harder to take a vacation because you'll be able to review your bills and do everything, you know, on whatever device you've got. It's probably something in your glasses that you'll be seeing all of this stuff in. So I think the connections and the information is going to continue to come in at a greater pace, and the challenge will be, how do you keep track of this information? How do you triage all of this massive thing that's coming to you so you can decide where is it I can best spend my time? That's going to be our challenge.
Indeed. Well, thank you very much, gentlemen, both of you. I think we've learned I think we've learned an awful lot today about how the legal department has evolved, how technology is gradually helping us with day-to-day tasks and everything. So I hope you found that educative too, and thank you very much and goodbye.